wait a second, give everybody time to settle down and get out. You can go ahead and be seated. We'll hear from the appellant.
If I may reserve 5 minutes for rebuttal.
Yes, that'll be fine.
Good morning, Your Honors. My name is Jerry Fabus, and I certainly don't envy your job after listening to the oral argument on that last case. I'm not sure I understood half of it. This will be a lot more straightforward. First off, I'd like to point out this is a post-divorce case, and after reading the appellee's brief, I would like to point out that what I'm appealing was the February 28th, 2024 order, not the September 19th, 2023 order. So I believe my appeal is timely filed. It's my Rule 60 motion that I'm asking you to look at and reverse the trial court's ruling. Now, when you read my brief, you're going to see that almost all of the facts relate back to the entry of the September 19th, 2023 consent order. So my brief will read that in effect, I am asking you to end up vacating that judgment that was entered on September 19, 2023. But as far as the timeliness of my appeal, that's not what I appealed. I appealed the Rule 60 motion. Now, I was not the defendant's attorney at trial in this matter. She had a different attorney. She had Julie Cantor, so I had to piecemeal some of the information from my client and then from the court record. It appears on July 7th of 2023 that both attorneys with both parties appeared before Chancellor Jenkins in Hawkins County, Tennessee, for a divorce trial, and they announced to the court that they had reached an agreement and the case had settled. Thereafter, Ms. Cantor filed a notice of revocation to the consent on July 10th and filed it with the court. This is before anything had been reduced to writing. There's no MDA that's ever been signed by the parties. Thereafter, Ms. Cantor had to withdraw from the case because she received a general sessions judge position in Johnson County, Tennessee, so she had to shut down her private practice. So Chancellor Jenkins gave my client time to hire new counsel, which she did. I filed a notice of appearance with the court within a timely matter. Then on September 19th, 2023, opposing counsel appears in front of Chancellor Jenkins and has him sign a consent order that neither Ms. Cantor, myself, or the defendant had ever read. We'd never set eyes on it. As soon as I found out that that had happened, I filed within a couple weeks of my Rule 60 motion to set that aside. My honest assumption was that Chancellor Jenkins hadn't noticed that the consent, the revocation had been sent into the court and he just might have overlooked it in the file. So I thought the Rule 60 motion would get granted. That ended up being heard in January of 2024. An order was entered from that hearing February 28th. Chancellor Jenkins denied my motion to set it aside, even though there clearly had been, consent had been revoked at the time that that consent order was signed. So it's our position that you should reverse the ruling on my Rule 60 motion, which would then vacate the September 19th consent order that was entered without consent. When I briefed it, I did find 2 Tennessee Supreme Court cases that I thought were almost dead on point, so I don't think this should be a real complicated issue. That's all I have for now. Thank you.
We'll hear from the appellee.
Judge, I may not need it, Chief Justice, but if I could reserve 5 minutes.
The appellee doesn't get to reserve.
Okay, I'll just go ahead then. This is a case that, first I'll argue that it was an untimely appeal. The appeal was filed nearly 5 months after the final.
I'm sorry. Did you introduce yourself?
Jeremy Harr for
okay.
the
Thank
appellee.
You. So it's on the record.
Yes, Your Honor. This is an appeal that was filed untimely. This was filed 5 months after a final judgment was entered. This was a Rule 60 motion to set aside the judgment. The case that the appellant cites, the Harbor case, talks about consent. And that consent has to exist at the very moment the court undertakes to make the agreement, the judgment of the court. This was a case that was set for trial. The parties, the record is clear, the parties appeared before Chancellor Jenkins. The chancellor placed the parties under oath. They stipulated that they had grounds for divorce from each other. They stipulated that they had divided assets and that and we announced a full and final dissolution to the court. What property each party would retain, and the court found and asked the parties if that division was fair and equitable to both of them. After that happened, the divorce judge, Chancellor Jenkins, divorced the parties that day. So the court ordered the parties divorced. Afterwards, after the case was over and before we could send in an order reflecting the chancellor's ruling, Ms. Canner filed a motion to withdraw and filed a revocation of consent. There was basically a mini trial for all intents and purposes because the parties were under oath. The parties stipulated to grounds for divorce and stipulated what the terms of the divorce was. The judge inquired whether it was fair and equitable to both. They both said this was a fair and equitable agreement to both of us. They both asked the court to divorce them, and the court divorced them that day. Later, we had as the record will reflect, a motion to set aside. And there's no reason to set aside. There was no allegation of mistake, fraud, duress, anything like that. It was a motion to set aside. The court again conducted a hearing and placed both parties under oath, and both parties testified that they swore under oath that they had divided and they had announced an agreement to the court and that there was grounds for a divorce, and my client testified to what the terms were, and nobody objected that the final order was inaccurate. So there is no question, nothing has been raised that the court order that was entered, that was final, was inaccurate in any ways. Quite to the contrary, both parties have been under oath in front of Chancellor Jenkins 2 times, stating that the court order, it was a correct order.
Excuse me for interrupting. Did the trial court treat this as Rule 60 or a Rule 59?
The court treated it as a Rule 60. And as a Rule 60, my understanding is that this appeal would be dead on arrival because the statute would have run to appeal 30 days after the entry of the final judgment. The court treated this as a Rule 60. The brief does not, the appellant's brief does not even discuss this motion to set aside. The correct thing to argue on appeal, in my opinion, would be to argue that there was some error on the motion to set aside. The chancellor conducted that hearing absolutely correct. There was nothing in this brief that has been indicative at all that Chancellor Jenkins made any mistake in granting the divorce, nor is there any argument here that Chancellor Jenkins made a mistake in conducting his Rule 60 hearing. We appeared, both parties appeared, both parties were represented by counsel at this Rule 60 motion, and the court denied it. And that Rule 60 motion, the denial of the Rule 60 motion, was not appealed. So this appeal is untimely because it only argues that the July-September judgment is incorrect. So and the time the appeal was filed, almost the time had told by more than triple. If the court was to treat a Rule 60 motion, as the court could, and infer that it was a Rule 59, then the court could look at this as a timely appeal. And if we get to the point where the court does treat the Rule 60 as a 59, It's not labeled that way, and it's not argued that way. Then if you were to govern this as a non-final judgment, the elements are not met based on the record that's before this court.
Excuse me for interrupting again. Was there testimony and evidence presented during the Rule 60 hearing?
Yes, there was, Your Honor. There was testimony and evidence presented at the Rule 60 hearing, and that evidence is in the record. At that Rule 60, both parties testified, and both parties testified that the judge had divorced them at the previous hearing. Both parties testified under oath that they had told the judge that the agreement announced as far as the division of assets was fair and equitable to both of them. And both parties also reiterated and testified that they agreed that they had stipulated grounds for the divorce. So there was, in essence, a trial by stipulation. This was not a consent where you walk into a courtroom and you, as we often do, and say, Judge, we've got an agreement, we'll send you an order. That's not what happened. Both these parties went under oath. Both of them gave testimony. The judge queried them, and he made certain that it was a fair and equitable division of assets and debts. He made sure that there were stipulated grounds, and he spoke, and he said, I find the parties are divorced. You're divorced here today, and we left that courthouse divorced. It was just simply doing an order confirming what the chancellor had ruled from the bench. So that is the elements of the case. What I would also bring into light is that the court, when the court took the evidence on the Rule 60, the court made the same findings that both parties were present, had counsel, new counsel. This was new counsel for the Rule 60 hearing. And the court, after hearing testimony and argument of counsel at Rule 60, denied the Rule 60 motion. So there's two separate occurrences where the parties were under oath and testified that the divorce agreement was the agreement that existed. My last issue that I will address before the court is the issue that we have asked for attorney fees, because we feel it's appropriate that this appeal is frivolous and seemingly sought for the purpose of delay and bad faith. And I say that because when you come to the Court of Appeals, you argue that there is a misunderstanding of the law. You argue that the trial court, or if you appeal from general sessions to circuit court, you say the judge misinterpreted the law, or there's a conflict of law, or there's something wrong with the law. There's nothing wrong with the law here. This appellant agreed to a divorce, agreed to the terms of the divorce, and left the courthouse divorced. And then afterwards, for reasons unknown, she decided she wanted to renegotiate the divorce, and she wanted to rescind and set aside a divorce that was final. So her attorney filed something to a notice to rescind. There was nothing to rescind at that point, but she filed a notice of rescission. She withdrew from the case. So the record shows clearly that this is, Mr. Fabus is the third lawyer, and that it was well informed that there was a trial that day, well informed that she was with counsel. She had counsel before Miss Cantor. She had Mr. Williams and Miss Cantor for the date of the trial. There was absolutely no mistake. It was 100% clear, and the judge issued an order. And the whole purpose of an order is when the judge orders something from the bench, everything after that's just a formality to do the order. The judge had ruled. The judge had taken all the facts and evidence, applied the law, and ruled. and then we had the Rule 60. He took the facts, evidence, everybody under oath again, and ruled again. So Ms. Grimm had 2 bites at the apple in front of Chancellor Jenkins on this, what should have been a simple divorce case with no children. 2 bites at the apple, and then now we're here, and we feel that the appeal is frivolous and for the purpose of delay of the divorce. Is there any other questions?
I hear none. Thank you.
Thank you, Your Honors.
Hear from the appellant rebuttal.
Yes, judges. Respectfully, I just asked you to go through the record carefully. I was not the trial attorney on this. About 80% of what Mr. Haar respectfully is stating is nowhere in any court records because there wasn't a court reporter. There was not an actual trial that date. It was something informal where they said, Chancellor, we've got an agreement. He probably swore him under oath, said, you guys got an agreement? They said yes, and then they left. There was no findings of fact.
What were they sworn in?
You'll have to check the transcripts. I don't know because I wasn't there and there isn't a transcript.
Well, neither were we.
Okay. You'll have to check that. I know Mr. Haar is stating that they were. I wasn't there. You'll have to see if that issue came up in my Rule 60 motion. There was proof in the Rule 60 motion. I did have a court reporter there, and the court record really is pretty sparse. I mean, there were some, not that it's relevant
Were they
necessarily,
sworn in, were the parties sworn in at the Rule 60 hearing?
Yes, I can tell you they were there. I had a court reporter. They were sworn in there. And it's not going to be a real long transcript. It wasn't a real long hearing.
All right.
But yeah, they were sworn in at that one at least. So respectfully, I think my Rule 60 motion was timely filed, and it should be granted, which should vacate that divorce because it was not a consent decree at that point in time.
All right. Thanks to all counsel for your oral argument and your brief. If you would, adjourn court till our next regularly scheduled docket.